You know that feeling when a promise sounds just a little too good to be true? Well, what happens when that promise isn't just a sales pitch, but it's the actual foundation of a contract you just put your name on? Today, we are diving deep into the legal world of misrepresentation, what it really means when a deal is built on a lie, and, more importantly, what on earth you can do about it.
So, let me ask you this. Have you ever been talked into a deal only to find out way later that the information you were given was, well, just flat out wrong? It's a seriously frustrating feeling, right? And it happens way more often than you'd think. From buying a car to a house, the truth really matters. Okay, let's make this real with a classic example. Imagine a seller is trying to convince you to buy a property, and they tell you it's a fantastic investment because it's fully let. Sounds amazing, doesn't it? A guaranteed income stream from day one. But what if they just kind of forget to mention that every single one of those tenants has already handed in their notice to leave? Whoops. All of a sudden, your great investment is just an empty building waiting to drain your bank account. See, that isn't just a clever sales tactic. It's a half-truth that paints a dangerously false picture. And in the world of contract law, that is a very big deal.
So, to really get a grip on all this, here's our game plan. We're going to break down what makes a false statement something you can actually take action on. We'll navigate those tricky gray areas, like sales puffs and when silence is a problem. Then we'll get into the different shades of misrepresentation, and finally, we'll look at the legal tools you have to actually fix the mess.
Right, so to make a legal claim actually stick, it's not enough to just show up and say, hey, they lied to me. The law has this very specific recipe, a list of ingredients that absolutely must be there. So let's get into what those are. There are 4 essential ingredients. First, and this is pretty obvious, there has to be an untrue statement. Second, it's got to be a statement of fact or law, not just some vague boast. Third, it has to be addressed to you, the person who's entering the contract. And fourth, and this one is the real kicker, that statement has to be one of the reasons you were persuaded to sign on the dotted line in the first place. But here's where it gets interesting. Not every untrue statement is going to get you a day in court. The law actually carves out some exceptions for things like advertising fluff or someone's honest opinion, and in a lot of cases, for just keeping your mouth shut. So let's dive into these gray areas where the lines can get a little blurry. This slide shows a fantastic contrast. When a real estate agent calls a house a desirable residence, the law just sees that as a mere puff. It's sales talk, it's hot air, it's totally subjective, and you can't sue over it. But if that same seller deliberately slaps a coat of paint over a giant patch of dry rot, well, their action is making a statement of fact that this wall is perfectly sound, and that is absolutely something you can take action on.
And the same idea applies to opinions. It all comes down to expertise. So let's say a farmer who's never actually raised sheep on his land gives you his honest guess that it could hold, say, 2,000 sheep. If he's wrong, well, it's just a bad opinion from a non-expert. But if a massive oil company with teams of analysts gives a potential gas station owner a flawed sales forecast, their opinion carries the weight of fact. Why? Because they're the experts, they're implicitly stating, hey, we've done the math on this.
This is just a brilliant quote that gets to the heart of another tricky area: your intentions. It shows how even a statement about the future can be a lie about the present. So, if a company raises money claiming they intend to expand the business, but secretly they're actually planning to just pay off old debts, they've misrepresented a current fact, their true intention. Just like the quote says, what's going on in your head right now is a fact.
Generally speaking, you're not legally required to spill all the beans. Silence isn't misrepresentation. But, and this is a big but, there are crucial exceptions. Remember that fully let property? That's a misleading half-truth. Then there's this idea of a continuing representation. If a doctor sells his practice and states its income, but then his income tanks right before the sale goes through, he has a duty to correct himself. And finally, some contracts, like insurance, are all about utmost good faith. That means you are required to disclose every single relevant fact, whether they ask or not.
Okay, so we've got the basic ingredients down. Now let's add another layer. Once you've figured out that yes, an actionable misrepresentation has happened, the law then needs to classify it. It basically recognizes 3 different types or shades, and it all depends on the mindset of the person who made the false statement.
First up, we've got the most serious one: fraudulent misrepresentation. This is a deliberate, straight-up lie, pure and simple. The person who said it either knew it was false, didn't believe it was true, or was just so reckless they didn't care one way or the other. This is all about intentional deceit. In the middle of the spectrum, we have negligent misrepresentation. Now, this isn't about being dishonest. It's about being careless. The person made a false statement because they didn't have any good reason to believe it was true.
And here's the really crucial part. The burden of proof actually flips. It's up to the person who made the statement to prove they had reasonable grounds to believe it, not for you to prove they didn't. And trust me, that's a huge legal advantage. And finally, there's innocent misrepresentation. This is exactly what it sounds like, an honest mistake. The person genuinely believed what they were saying was true, and they had good reason for that belief. It just turned out they were wrong, through no real fault of their own.
So the worst has happened. A misrepresentation was made, and you signed a contract because of it. The huge question now is, what can you actually do? Let's get into the legal remedies that are designed to undo all that damage.
The number one goal and your main weapon is something called rescission. Honestly, just think of it as a giant undo button for the entire contract. The court's aim is to set the deal aside as if it never even happened, putting everyone back in the exact financial position they were in before the whole mess started.
But you can lose the right to hit that undo button. For instance, if you find out about the lie but decide to just carry on with the contract anyway, that's called affirmation, and you're stuck. If you wait too long, like in a famous case where a guy bought a painting, found out 5 years later it wasn't by the artist he thought, the court said, sorry, you're too late. And of course, you can't undo a deal if it's impossible to give things back, or if the item's already been sold to an innocent person.
And here is where it all comes together beautifully. This simple table gives us the bottom line. For both fraudulent and negligent misrepresentation, you can get rescission, that's the undo button, and you can sue for financial damages. For an innocent misrepresentation, you can get rescission but not damages. But, and this is a cool little twist, a judge actually has the power to award you damages instead of rescission if they think unwinding the whole contract would just be too extreme.
So what's the big takeaway from all this? It's that the words spoken before you sign on the dotted line have real legal power. It is not just small talk. Understanding the difference between a vague puff, an honest mistake, and an actionable fact empowers you to listen more carefully, to ask better questions, and most importantly, to protect yourself. And that really just leaves us with one final thought. Knowing all of this now, how differently will you approach the promises made in your next big deal?